Elon Musk's AI chatbot, Grok, is now under investigation across multiple countries: Ireland, the European Union, the United Kingdom, Brazil, and more. At the center of the controversy? Allegations that Grok generated non-consensual intimate imagery involving real individuals, including minors. Regulators are now stepping in. And this isn't just about one chatbot. It could become a defining test case for how governments regulate generative AI on major platforms. Because when AI tools scale globally, accountability doesn't stay local, and Europe appears ready to draw a line.
Ireland's Data Protection Commission has formally opened an investigation into X, the social platform that hosts Grok. Because X's European headquarters are based in Dublin, Irish regulators serve as the lead supervisory authority for the company under European privacy law. That gives Ireland primary oversight responsibility across the EU. The investigation will examine whether Grok's image generation features violated the General Data Protection Regulation, better known as GDPR, particularly in how personal data may have been processed when users generated altered images of real individuals. At the same time, the European Commission is conducting a separate review under the Digital Services Act. That framework requires large online platforms to properly assess and mitigate risks linked to illegal content and systemic harm. So this isn't a single inquiry, it's a dual-track regulatory response. One focused on privacy compliance, the other focused on platform responsibility and safety obligations. Together, they place X and Grok under serious legal scrutiny across Europe.
Regulators are examining reports that Grok's image generation feature allowed users to create altered images of real individuals without their consent. According to official statements, some of those outputs allegedly involved sexualized content and in certain reported cases may have included minors. That is where the legal exposure becomes significantly more serious. X has stated that it introduced restrictions and updated its policies once concerns were raised. The company says it has taken steps to limit the generation of inappropriate imagery. However, regulators are now assessing whether those safeguards were adequate and whether they were implemented in a timely manner. The investigation centers around several critical questions. Did X conduct a thorough risk assessment before rolling out Grok's image tools? Were sufficient safety guardrails in place at launch? And was personal data processed in compliance with GDPR standards? These are not minor technicalities. They address the fundamental responsibility companies carry when deploying generative AI systems at scale. Because once an AI tool is publicly accessible, its risks can multiply rapidly, and regulators want to know whether those risks were anticipated or overlooked.
Ireland is not acting in isolation. Regulatory scrutiny is expanding beyond a single jurisdiction. Authorities in the United Kingdom, France, and Brazil have also initiated reviews or investigations related to Grok's image generation features. In the UK, Ofcom, the national communications regulator, is assessing the matter under the Online Safety Act, which grants broad powers to examine how platforms manage harmful or unlawful content. In France, prosecutors have reportedly reviewed complaints tied to the chatbot's outputs, adding potential legal dimensions beyond administrative fines. And in Brazil, the National Data Protection Authority has ordered corrective measures, signaling that concerns are not limited to Europe alone. What we are seeing is multi-country regulatory pressure unfolding simultaneously. That matters, because when investigations begin to overlap across privacy law, platform safety law, and criminal statutes, the compliance burden increases significantly. This is no longer a local controversy. It's becoming a global regulatory stress test, and it signals a broader shift. Governments are no longer relying on voluntary safeguards from AI companies. They are stepping in, directly and in coordination, to enforce accountability.
If regulators determine that violations occurred, the financial consequences could be substantial. Under GDPR, penalties can reach up to 4% of a company's global annual revenue. Under the Digital Services Act, fines can climb even higher, potentially up to 6%, depending on the severity of noncompliance. For a platform the size of X, and one closely integrated with Musk's broader AI strategy, that level of exposure is not trivial. But the risk isn't limited to monetary penalties. Regulatory findings can affect public trust, brand reputation, investor confidence, especially at a time when Musk's ecosystem, including AI and potential public market activity, is under increased scrutiny. For companies positioning themselves at the center of the AI economy, regulatory credibility becomes a strategic asset. Beyond the legal specifics, this case highlights a deeper structural tension in the AI race. Generative AI systems are being launched at extraordinary speed. Image tools, video tools, language models, all scaling globally within months. But regulatory systems operate differently. They evolve through legislation, interpretation, and enforcement, often at a slower pace. When AI tools are deployed rapidly across millions of users, even small oversight gaps can multiply quickly. Millions of prompts, millions of outputs, and potentially millions of compliance risks. The Grok situation forces a difficult but necessary question. Can innovation move at full speed without outpacing governance and responsibility? Europe, in particular, has taken a proactive stance on digital regulation, from GDPR to the Digital Services Act and now the AI Act. And generative AI is no longer operating in a regulatory gray zone. It is firmly within the scope of structured oversight, which means the era of launch first, adjust later may be ending.
Elon Musk has often characterized regulatory scrutiny as excessive or politically motivated, particularly when it involves content moderation or speech policies. However, in response to the concerns surrounding Grok, X has updated its policies and reportedly introduced restrictions on certain image generation capabilities. The company has stated that it is cooperating with regulators and engaging in ongoing discussions with supervisory authorities. But in compliance investigations, regulators look beyond public statements. They examine timelines. When were concerns first raised? When were safeguards implemented? And were those measures proactive or reactive? In data protection and platform safety cases, timing carries legal weight, because responsibility is not measured only by what was fixed, but by how quickly it was addressed. This story isn't just about Grok, and it isn't just about one company. It represents a broader inflection point in the relationship between generative AI and global regulation. If regulators determine that safeguards were insufficient, the consequences could extend far beyond fines. We may see stricter pre-deployment reviews for AI tools, mandatory risk assessments before public rollout, and stronger accountability standards for platforms operating at scale within Europe. The AI race is accelerating at remarkable speed, but so is regulatory enforcement. And in the long term, the companies that endure may not simply be the fastest innovators. They will be the ones capable of aligning technological advancement with legal and ethical responsibility. For Elon Musk's X and for the wider AI industry, this moment may prove pivotal, because the future of generative AI will not be shaped by innovation alone. It will also be shaped by accountability.